Although, as has already been said, the Constitution is a paper that nobody ever signed, that few persons have ever read, and that the great body of the people never saw, and that has, consequently, no more claim to be the supreme law of the land, or to have any authority whatever, than has any other paper that nobody ever signed, that few persons ever read, and that the great body of the people never saw. And although it purports to authorize a government in which the lawmakers, judges, and executive officers are all to be secured against any responsibility whatever to the people whose liberty and rights are at stake. And although this government is kept in operation only by votes given in secret, by secret ballot, and in a way to save the voters from all personal responsibility for the acts of their agents, the lawmakers, judges, etc., and although the whole affair is so audacious a fraud and usurpation that no people could be expected to agree to it, or ought to submit to it for a moment, yet, inasmuch as the Constitution declares itself to have been ordained and established by the people of the United States for the maintenance of liberty and justice for themselves and their posterity, and inasmuch as all its supporters, that is, the voters, lawmakers, judges, etc., profess to derive all their authority from it, and inasmuch as all lawmakers and all judicial and executive officers, both national and state, swear to support it, and inasmuch as they claim the right to kill and are evidently determined to kill, and esteem it the highest glory to kill all who do not submit to its authority, we might reasonably expect that, from motives of common decency, if from no other, those who profess to administer it would pay some deference to its commands, at least in those particular cases where it explicitly forbids any violation of the natural rights of the people. Especially might we expect that the judiciary, whose courts claim to be courts of justice, and who profess to be authorized and sworn to expose and condemn all such violations of individual rights as the Constitution itself expressly forbids, would, in spite of all their official dependence on and responsibility to the lawmakers, have sufficient respect for their personal characters and the opinions of the world, to induce them to pay some regard to all those parts of the Constitution that expressly require any rights of the people to be held inviolable. If the judicial tribunals cannot be expected to do justice, even in those cases where the Constitution expressly commands them to do it, and where they have solemnly sworn to do it, it is plain that they have sunk to the lowest depths of servility and corruption, and can be expected to do nothing but serve the purposes of robbers and tyrants. But how futile have been all expectations of justice from the judiciary may be seen in the conduct of the courts, and especially in that of the so-called Supreme Court of the United States, in regard to men's natural right to make their own contracts. Although the state lawmakers have, more frequently than the national lawmakers, made laws in violation of men's natural right to make their own contracts, yet all laws, state and national, having for their object the destruction of that right, have always, without a single exception, I think, received the sanction of the Supreme Court of the United States. And having been sanctioned by that court, they have been, as a matter of course, sanctioned by all the other courts, state and national. And this work has gone on until, if these courts are to be believed, nothing at all is left of men's natural right to make their own contracts.
That such is the truth I now propose to prove. And first, as to the state governments. The Constitution of the United States, Article 1, Section 10, declares that no state shall pass any law impairing the obligation of contracts. This provision does not designate what contracts have and what have not an obligation, but it clearly presupposes, implies, assumes, and asserts that there are contracts that have an obligation. Any state law, therefore, which declares that such contracts shall have no obligation, is plainly in conflict with this provision of the Constitution of the United States. This provision also, by implying that there are contracts that have an obligation, necessarily implies that men have a right to enter into them. For if men had no right to enter into the contracts themselves could have no obligation. This provision, then, of the Constitution of the United States not only implies that there are contracts that have an obligation, but it also implies that the people have the right to enter into all such contracts and have the benefit of them. And any state law conflicting with either of these implications is necessarily unconstitutional and void. Furthermore, the language of this provision of the Constitution, to wit, the obligation singular of contracts, plural, implies that there is one and the same obligation to all contracts whatsoever that have any legal obligation at all. And there obviously must be some one principle that gives validity to all contracts alike that have any validity. The law, then, of this whole country, as established by the Constitution of the United States, is that all contracts whatsoever in which this one principle of validity, or obligation, is found shall be held valid, and that the states shall impose no restraint whatever upon the people's entering into all such contracts. All, therefore, that courts have to do in order to determine whether any particular contract or class of contracts are valid and whether the people have a right to enter into them is simply to determine whether the contracts themselves have, or have not, this one principle of validity or obligation, which the Constitution of the United States declares shall not be impaired. State legislation can obviously have nothing to do with the solution of this question. It can neither create nor destroy that obligation of contracts, which the Constitution forbids it to impair. It can neither give nor take away the right to enter into any contract whatever that has that obligation. On the supposition, then, that the Constitution of the United States is what it declares itself to be, that is, the supreme law of the land, anything in the constitutions or laws of the states to the contrary notwithstanding, this provision against any state law impairing the obligation of contracts is so explicit and so authoritative that the legislatures and courts of the states have no color of authority for violating it, and the Supreme Court of the United States has had no color of authority or justification for suffering it to be violated. This provision is certainly one of the most important, perhaps the most important, of all the provisions of the Constitution of the United States, as protective of the natural rights of the people to make their own contracts, or provide for their own welfare. Yet, it has been constantly trampled underfoot by the state legislatures, by all manner of laws, declaring who may and who may not make certain contracts, and what shall and what shall not be the obligation of particular contracts, thus setting at defiance all ideas of justice, of natural rights, and equal rights, conferring monopolies and privileges upon particular individuals, and imposing the most arbitrary and destructive restraints and penalties upon others, all with a view of putting, as far as possible, all wealth into the hands of the few, and imposing poverty and servitude upon the great body of the people. And yet all these enormities have gone on for nearly 100 years and have been sanctioned, not only by all the state courts, but also by the Supreme Court of the United States. And what color of excuse have any of these courts offered for thus upholding all these violations of justice, of men's natural rights, and even of that Constitution which they had all sworn to support?
They have offered only this. They have all said they did not know what the obligation of contracts was. Well, suppose, for the sake of the argument, that they have not known what the obligation of contracts was, what then was their duty? Plainly this, to neither enforce nor annul any contract whatever, until they should have discovered what the obligation of contracts was. Clearly they could have no right to either enforce or annul any contract whatever, until they should have ascertained whether it had any obligation, and, if any, what that obligation was. If these courts really do not know, as perhaps they do not, what the obligation of contracts is, they deserve nothing but contempt for their ignorance. If they do know what the obligation of contracts is, and yet sanction the almost literally innumerable laws that violate it, they deserve nothing but detestation for their villainy. And until they shall suspend all their judgments for either enforcing or annulling contracts, or, on the other hand, shall ascertain what the obligation of contracts is, and sweep away all state laws that impair it, they will deserve both contempt for their ignorance and detestation for their crimes. Individual justices of the Supreme Court of the United States have, at least in one instance, in 1827, Ogden versus Saunders, 12 Wheaton 213, attempted to give a definition of the obligation of contracts, but there was great disagreement among them, and no one definition secured the assent of the whole court or even of a majority. Since then, so far as I know, that court has never attempted to give a definition. And, so far as the opinion of that court is concerned, the question is as unsettled now as it was 60 years ago, and the opinions of the Supreme Courts of the states are equally unsettled with those of the Supreme Court of the United States. The consequence is that the obligation of contracts, the principle on which the real validity or invalidity of all contracts whatsoever depends, is practically unknown, or at least unrecognized by a single court, either of the states or of the United States. And, as a result, every species of absurd, corrupt, and robber legislation goes on unrestrained, as it always has done. What now is the reason why not one of these courts has ever so far given its attention to the subject as to have discovered what the obligation of contracts is? What that principle is, I repeat, which they have all sworn to sustain, and on which the real validity or invalidity of every contract on which they ever adjudicate depends. Why is it that they have all gone on sanctioning and enforcing all the nakedly iniquitous laws by which men's natural right to make their own contracts has been trampled underfoot? Surely, it is not because they do not know that all men have a natural right to make their own contracts, for they know that, as well as they know that all men have a natural right to live, to breathe, to move, to speak, to hear, to see, or to do anything whatever for the support of their lives or the promotion of their happiness. Why, then, is it that they strike down this right without ceremony and without compunction whenever they are commanded to do so by the lawmakers? It is because, and solely because, they are so servile, slavish, degraded, and corrupt as to act habitually on the principle that justice and men's natural rights are matters of no importance in comparison with the commands of the impudent and tyrannical lawmakers on whom they are dependent for their offices and their salaries. It is because, and solely because, they, like the judges under all other irresponsible and tyrannical governments, are part and parcel of a conspiracy for robbing and enslaving the great body of the people, to gratify the luxury and pride of a few. It is because, and solely because, they do not recognize our government, state or national, as institutions designed simply to maintain justice or to protect all men in the enjoyment of all their natural rights, but only as institutions designed to accomplish such objects as irresponsible cabals of lawmakers may agree upon.
In proof of all this, I give the following. Previous to 1824, 2 cases had come up from the state courts to the Supreme Court of the United States, involving the question whether a state law, invalidating some particular contract, came within the constitutional prohibition of any law impairing the obligation of contracts. One of these cases was that of Fletcher v. Peck, 6 Cranch 87, in the year 1810. In this case, the court held simply that a grant of land, once made by the legislature of Georgia, could not be rescinded by a subsequent legislature, but no general definition of the obligation of contracts was given. Again, in the year 1819, in the case of Dartmouth College v. Woodward, 4 Wheaton 518, the court held that a charter granted to Dartmouth College by the King of England before the Revolution was a contract, and that a law of New Hampshire annulling or materially altering the charter without the consent of the trustees was a law impairing the obligation of that contract. But in this case, as in that of Fletcher v. Peck, the court gave no general definition of the obligation of contracts. But in the year 1824, and again in 1827, in the case of Ogden v. Saunders, 12 Wheaton 213, the question was whether an insolvent law of the state of New York, which discharged a debtor from a debt, contracted after the passage of the law, or, as the courts would say, contracted under the law, on his giving up his property to be distributed among his creditors, was a law impairing the obligation of contracts? To the correct decision of this case, it seemed indispensable that the court should give a comprehensive, precise, and universal definition of the obligation of contracts, one by which it might forever after be known what was, and what was not, that obligation of contracts which the state governments were forbidden to impair by any law whatever. The cause was heard at 2 terms, that of 1824 and that of 1827. It was argued by Webster, Wheaton, Wirt, Clay, Livingston, Ogden, Jones, Sampson, and Haynes, 9 in all. Their arguments were so voluminous that they could not be reported at length. Only summaries of them are given. But these summaries occupy 38 pages in the reports. The judges at that time were 7, that is, Marshall, Washington, Johnson, Duval, Story, Thompson, and Trimble. The judges gave 5 different opinions, occupying 100 pages of the reports. But no one definition of the obligation of contracts could be agreed on, not even by a majority. Here, then, 16 lawyers and judges, many of them among the most eminent the country has ever had, were called upon to give their opinions upon a question of the highest importance to all men's natural rights, to all the interests of civilized society, and to the very existence of civilization itself, a question upon the answer to which depended the real validity or invalidity of every contract that ever was made or ever will be made between man and man. And yet, by their disagreements, they all virtually acknowledged that they did not know what the obligation of contracts was. But this was not all. Although they could not agree as to what the obligation of contracts was, they did all agree that it could be nothing which the state lawmakers could not prohibit and abolish by laws passed before the contracts were made. That is to say, they all agreed that the state lawmakers had absolute power to prohibit all contracts whatsoever for buying and selling, borrowing and lending, giving and receiving property, and that, whenever they did prohibit any particular contract or class of contracts, all such contracts thereafter made could have no obligation. They said this, be it noted, not of contracts that were naturally and intrinsically criminal and void, but of contracts that were naturally and intrinsically as just and lawful and useful and necessary as any that men ever enter into, and that had as perfect a natural, intrinsic, inherent obligation as any of those contracts by which the traffic of society is carried on, or by which men ever buy and sell, borrow and lend, give and receive, property of and to each other. Not one of these 16 lawyers and judges took the ground that the Constitution, in forbidding any state to pass any law impairing the obligation of contracts, intended to protect against the arbitrary legislation of the states, the only true, real, and natural obligation of contracts, or the right of the people to enter into all really just and naturally obligatory contracts. Is it possible to conceive of a more shameful exhibition or confession of the servility, the baseness, or the utter degradation of both bar and bench than their refusal to say one word in favor of justice, liberty, men's natural rights, or the natural and only real obligation of their contracts? And yet, from that day to this, a period of 60 years save one, neither bar nor bench, so far as I know, have ever uttered one syllable in vindication of men's natural right to make their own contracts, or to have the only true, real, light, natural, inherent, intrinsic obligation of their contracts respected by lawmakers or courts. Can any further proof be needed that all ideas of justice and men's natural rights are absolutely banished from the minds of lawmakers and from so-called courts of justice? Or that absolute and irresponsible lawmaking has usurped their place? Or can any further proof be needed of the utter worthlessness of all the constitutions which these lawmakers and judges swear to support and profess to be governed by?